Yes, Mr. Lightman. I can tell you that we've read the relevant parts of the judge's judgment and the skeleton arguments and the three little authorities that you gave us, four authorities.
I'm grateful, my Lord. Good morning. In this appeal, I represent the appellant, Docklock Ltd, together with my learned friend, Mr Comiskey, my learned friends, Mr Letman and Mr Shah, that appear on behalf of the respondent, Christo Co Ltd. This appeal arises out of an account of rent which Christo received for Docklock during the 23-month period between the 1st of October 2014 and the 1st of September 2016, which I'll refer to as the relevant period, where that is simply part of a longer period during which Christo was receiving rent for and providing property management services to Docklock. This appeal is brought on two grounds. The first and primary ground concerns the correct approach to appropriation on a running account, and whether the judge, then Tom Leach QC, now Mr Justice Leach, was correct to hold that the first-in-time approach was not to be followed in the context of the account that he had to take. Under this ground, Docklock argues that the judge was wrong to bring into account three payments made between the 7th and the 24th of October 2014, what are referred to as the first disbursements, which were in fact paid out of rents which Christo had received prior to the relevant period. The effect of this, Docklock submits, has been to allow Christo to double count payments out it has made to Docklock, and thereby to retain, wrongfully and in breach of fiduciary duty, the sum of £134,118.72 out of money which it held on trust for Docklock. It is worth emphasising that it must be Christo's case that, unless the appeal is successful, it will retain a sum which was under a fiduciary obligation to pay to Docklock. Now, Docklock's primary position is that the judge's approach to the first distributions was wrong. However, if that first ground fails, under the second ground, Docklock argues that the judge approached a particular disbursement of certain staff salaries, which Christo paid itself, inconsistently with the approach he'd adopted in relation to the first disbursements. Before going into the background, I just want to make one point. Lady Justice Falk, when giving permission to appeal, stated, this is at divider 1, page 1, that she recommended an attempt at mediation, and a mediation did take place on the 15th of September 2023, but unfortunately was unsuccessful, hence we're here today. Now, moving to the background, Docklock, the claimant, and Christo, the defendant, were two of several companies owned by Christoforou and or members of his family as part of a family property holding and property management business. Christo was a property management business which was solely owned by Chris. Nicholas, one of the two sons of Chris and his wife Betty, had been a director of Christo, but Chris removed him as a director after he'd been served with Betty's divorce proceedings. Docklock was a property-owning company owned in equal shares by Chris and Betty. Although Chris had at one time been a director of Docklock, at the relevant times its directors were Betty and Nicholas. Docklock's property portfolio had been managed by Christo. It is not entirely accurate to characterise Christo's retainer by Docklock as a major part of its business, as is stated at paragraph 7 of a respondent's skeleton of this appeal. Christo provided services to Docklock to reduce the costs of running the property business by keeping profits within the family businesses. In the course of the matrimonial proceedings, Chris described the family property business as follows: a single business, despite being operated through the mechanism of a number of limited companies. They have a symbiotic relationship. On the 9th of February 2015, Docklock gave notice to Christo to terminate its retainer. However, Docklock could not terminate the retainer at that point because of the injunction which Chris had obtained without notice on the 12th of February 2015, which restrained Betty and Nicholas from causing Docklock to act on that notice.
Sorry, what was the date of the notice?
The notice was 9th of February, so that's 3 days before the injunction, ex parte order. Although that injunction was eventually discharged on the 30th of September 2015, there followed further threats of action by Chris in his capacity as a shareholder in Docklock if Betty and Nicholas caused it to incur management charges by terminating the retainer. During the currency of the divorce proceedings, Christo, which remained under Chris's control, continued to collect in rents for Docklock's properties. However, it systematically failed to pass on to Docklock, which remained under the control of Betty and Nicholas, the rents which it had collected in. On the 23rd of August 2016, Docklock solicitors wrote to Christo requiring the disbursement of its funds. Christo's solicitors responded on the 16th of September 2016, denying any liability in relation to retained rent. As a result of this, Docklock terminated Christo's retainer. Now, I move on to see it in the context of the divorce proceedings and the order of Mr. Justice Moylan. In 2014, Betty commenced divorce and ancillary relief proceedings against Chris. They were served on the 19th of October 2014. Following a trial in 2016, Mr. Justice Moylan, as he then was, determined inter alia that Chris's shares in Docklock should be transferred to Betty. In the course of the final hearing, Betty asserted that Chris had caused Christo to retain rents which ought to have been paid to Docklock. Because Christo had not been ascribed any value, there was a concern that this would cause Chris to retain a larger share of a marital wealth. This issue was addressed at a further hearing which took place on the 19th of January 2017. And if we can go to Mr. Justice Moylan's supplemental judgment of that date, which is at supplemental bundles, divider 18.
18?
18, page 285. We go to paragraph 5, please. And he says this: at the final hearing, the wife alleged or raised an allegation that Christo & Co. had retained rental income paid to it and had not accounted to the companies which owned the properties for the sums due to them. As I said in paragraph 30 of my judgment, the latest accounts for Christo & Co. are as at 30th of April 2015. These show that Christo & Co.'s cash at the bank and in hand has increased over the year from 1.2 to 2.7 million, and that the amount due to creditors has increased from 1.6 to 3 million pounds. In his oral evidence, the husband said baldly that very little of this belongs to the family companies. Given my view as to the reliability of a husband as a witness, he will have to supply a breakdown of the relevant balances and the sums due to the companies as at the date of the distribution of the companies between the parties to ensure that he is not able to manipulate the figures and seek to obtain a larger share of the marital wealth by retaining funds within Christo & Co., which has not been ascribed a value in the asset schedule. And Mr. Justice Moylan went on to say, the end of that quote is of particular importance because Christo & Co., as I said, had not been ascribed a value in the asset schedule on a basis that it was not a company which had any independent value. All the other companies were valued for purposes of my judgment and determination. And Mr. Justice Moylan went on to say at paragraph 11, page 287, he says that the point remains the same. If Christo & Co. has retained cash, which should have been accounted for to the companies. This does not feature anywhere in the balance sheet or asset schedule, whereas it would have featured in the asset schedule if the monies had been accounted for. It is a discrete issue. And he says there's an element of, in my view, broad justice, and I'm not persuaded that to separate out this issue is unfair, because the parties might otherwise have retained or received an unequal share of the rental income derived from the overall property portfolio in this period, in particular since the hearing last April. And so he proposed to include as an exception any claim brought by Docklock against Christo Co and or Respondent in respect of monies received as agent for the applicant's companies for which it's asserted Christo Co have not duly accounted. And so if I include that, in my view, it would be unfair to Christo Co to deprive them of the ability, if it thought appropriate, to seek to argue that they should be entitled to deduct a management fee. And if I include that, I think it would be unfair on Docklock to prohibit them seeking to argue they'd be entitled to charge Christo Co for their occupation of Parkway. So I propose to include exceptions in A and B for the avoidance of doubt.
I infer that Mr Justice Moylan was considering a draft judgment, a draft agreement at that point. When he talks about exceptions in A and B, he says at 9, paragraph 9, Mr Southgate on behalf of the wife seeks the exclusion
Yes.
of monies not accounted for, and I assume that was embodied in some kind of draft which was put before the judge.
My Lord, I think the drafting process actually took place after.
Right, so
and I say
exceptions
that because,
A and B are then what?
I can take instruction, my Lord. What is clear is at that date, the actual details about it, for example, the relevant period, had not yet been negotiated. It was a matter of negotiation between the parties.
Right.
It wasn't a determination by Mr Justice Moylan as to what carve-out should be of 23 months. I understand the order itself is at divider 16, page 239, and you'll see that it's of the core bundle, sorry.
Yeah.
And you'll see that the date of that order is, and by then Mr Justice Moylan was in the Court of Appeal, was the 15th of May. So there was a period of almost 4 months between that hearing and the agreement of to the order, which, as you can see, is it's quite a detailed and lengthy order, running to 27 pages.
Yeah.
So, but what I understand is there wasn't actually a specific order. It may have been A and B were issues that have been raised in the skeleton argument, but I can give your lordship further chapter and verse.
Well, if it doesn't matter, then it doesn't matter.
No, the only point is, my lord, that the dates was a matter of agreement between the parties, rather than a specific determination by Mr Justice Moylan. The order itself, which I was going to come to now, is, I say, it the core bundle divider 16, and you'll see that the paragraph 15, which is page 243, explains what the underlying basis of the order at 15A. There should be a division of all the parties' assets, save for personal possessions, so as to achieve an essentially equal division between the parties by value and a clean break. You'll see, if you go on to page 258, paragraph 45, that this provides for the transfer by Chris of his shares in Docklock to Betty.
Sorry, where is that?
That's to page 258, paragraph 45, my lord.
And what's the completion date?
Completion date is the 19th of June 2017. That's at page 242. Paragraph 5D. The actual transfer was only affected of shares was actually only affected in October, my lord. And the exceptions to the clean break basis, as Mr Justice Moylan had determined on the 19th of January 2017, were set out in paragraph 19. You'll see introductory recitals at 17 and 18.
Going back to paragraph 45, it provides that the husband is to transfer to the wife not only the shares and the benefit of shareholders' loans, the bank accounts and the balances therein without deductions held by Christo Co designated for Docklock. Does that have any relevance to the current issue?
I'm informed that in fact there wasn't any. I understand well, there was a Docklock client account, but in fact no monies. But Docklock claimed, Christo claimed all of that money as client, as management fees.
I see.
So it didn't figure.
There was no transfer of any cash balance?
No.
No. Thank you.
So if we can go to page 244. You can see the introductory recitals of 17 and 18, which I invite your lordships to glance at. And then at paragraph 19, furthermore, parties agree that save in respect of the potential claims listed in subparagraphs A, B and C below, and save as otherwise provided elsewhere in this order, together with the mutual waiver agreement, I'll come to that in a minute, is intended to be in full and final satisfaction of all and any claims in England and Wales and any other jurisdiction that companies have against each other, the parties have against the companies, and the companies have against the parties. And it then says, the only exceptions to this are the following civil claims, subparagraphs A and B, and the exception at subparagraph C. And at A on page 245, any claim or counterclaim by any of the applicant's companies, the applicant being Betty, and the applicant's companies, and you can see that is defined as a term at page 242, as paragraph 5B, as the applicant's companies mean Arian and Docklock, against Christo and Co and or Respondent in respect of any monies received by Christo and Co as agent for any of the applicant's companies in respect of a period beginning of 1st of October 2014 and ending on the 1st of September 2016, for which it is asserted that the Respondent and or Christo & Co has not duly accounted to and or has not paid over to that company, including in respect of rent. And B, any claim or counterclaim by Christo & Co against any of the applicant's companies in respect of management fees for the period beginning 1st October 2014 up to 1st September 2016, which Christo & Co asserts are owing to it. And as I said, I mentioned the mutual waiver agreement is referred to at paragraph 19, page 244. At paragraph 23, it says, having executed the mutual waiver agreement at Schedule 4 here too, we don't appear to have that schedule here in the bundle. The applicant and respondent each undertake to the court to procure the execution of the mutual waiver agreement by or on behalf of their respective companies forthwith and in any event by the completion date. and to be bound by the terms of a mutual waiver agreement. And the agreement itself, the waiver of claims and indemnity agreement, is at divider 17, starting at page 267. Was actually entered into on the 26th of October 2017. So that's a few months after the completion date of the 19th of June 2017.
And the purpose of this was to get all the companies as parties.
Yes, because the Moylan order was only effective as against Chris and Betty personally. So Docklock, Christo, and other companies entered into this waiver of claims and indemnity agreement. You'll see at page 269 that, one and two at page 268 are Betty and Chris. At page 269, you'll see counterclaim, which is referred to in these proceedings, Christo and Co. and Docklock and Arian Developments above that, among other companies. And page 270, you'll see the further definitions adopted for parties to the agreement. Betty's companies, Arian, Docklock and Mountview. Chris's companies include Counterclaim, Christo and Co. and others. And at page 271, provides in consideration of the entry by the other parties into this agreement, and save as set out at paragraphs 2 and 3 below, you'll see at C, Betty's companies, which we're calling were Arian, Docklock and Mountview, hereby agree to do waive and enter into this agreement in full and final settlement of all and any claims and rights of action, either existing now or which may arise in the future, which any of them has or may have against Chris or any of Chris's companies arising out of the dealings between them to date. Chris's companies, which as I said were defined at page 4 to include Counterclaim and Christo and Co., agree to waive and enter into this agreement in full and final settlement of all and any claims and rights of action existing now, which may arise in the future, which any of them has or may have against Betty or any of Betty's companies arising out of the dealings between them to date. And then the only exceptions at page 272, and the wording is similar but not identical to the wording of Para 19 of the order in terms of the exceptions.
I mean, a particular distinction is that 2B has no end date.
Yes. That was an issue which was considered by Deputy Master Smith in the context of an application for summary judgment, and perhaps we can go to that, my lord, you having identified a relevant difference. That's a supplemental bundle divided 2. First of all, my lord, answering my lord's question about the purpose of the mutual waiver agreement. That's he says at page 7, paragraph 13. Of course, the order only bound only Mr Christoforou and Mrs Christoforou as the parties to the divorce proceedings. Therefore, paragraph 19 of the order envisaged the mutual waivers agreement. And at page 8, after setting out the relevant clauses of the mutual waiver agreement, Deputy Master Smith points out, as my Lord Justice Newey pointed out, that the clauses substantially set out the terms of clause 19, but they're not identical. For example, no end date of the 1st of September 2016 for claims to rent and management fees. And Parkway, which is not relevant here, also didn't have a start date. And he says, nonetheless, despite these differences, it's clear that clause 2 is based on the terms of the order. He then goes on to say, if we go to, you see paragraph 24, you see the context of it, page 12. It's an application for summary judgment, alternative interim payment. And on the issue of the interpretation, paragraph 34, page 17, Mr Smith says, on a literal reading, the language of clause 3 is consistent with defendant's submission that any set-off in relation to management fees is not restricted to those referable to the relevant period. But he goes on to say at paragraph 35, in my judgment, clause 3 of the MWA does not entitle the defendant to set off management fees and other outgoings incurred in relation to a period other than the relevant period. The MWA must be construed in the light of the judgments of Moylan J and the order. They form part of a matrix of fact, and the MWA and the order cross-refer to each other. Paragraph 19 of the order says the orders together with the MWA is in full and final satisfaction of the claims of the parties and the companies against each other, whilst paragraph 1 of the MWA states it's subject to the order. Perhaps I should have taken your lordship to that. They were intended to operate in tandem in order to ensure that all issues between the parties and the companies were dealt with as Moylan J intended, and the MWA was prepared in order to give effect to Moylan J's judgments. Therefore, the MWA must, if possible, be construed in a way that is consistent with the order and the judgments. And he...
So what actually happened between the 1st of September 2016 and the finalisation of the Moylan order and the mutual waiver agreement? Was Christo in fact managing the properties on behalf of Docklock during that interim period? And if so, what happened to the rent?
Well, it's until September 2016 that it was managing and receiving rents. From that date, it handed over to new managing agents. I can,
that was because of the termination, was it, of Christo's?
Yes.
Yeah.
Yes, I was going to sort of give a little bit more of that background a little bit later, but unless the lordship would be assistant to do that now.
So that's why the end date was chosen, was it? Because after the 1st of September 2016, Christo was no longer managing the properties on behalf of Docklock. Is that right?
Yeah, yes. Well, I mean, it's not in a precise correlation. The date of service of the divorce proceedings was October 2000, was the 19th of October 2014. The date on which Christo ceased to collect rents for Docklock was roughly 16th of September 2016. So I think there's a rough correlation between those two events, but then I guess for maybe for convenience they chose the first of the month.
Yeah.
So that's my understanding of the rough basis for the parties' agreement.
Your Lordship, I think broadly speaking that's correct, that sortie replacement managers were appointed about that time. But interesting, we in fact continued to receive rents from various of the tenants, which we continue to account for. That's the subject.
To Docklock?
To Docklock, yes. So in that, in effect, a run-off period.
My lords, so the termination of the Deputy Master Smith was that for example, at paragraph 38, he says, limiting the claims was always clearly intended to be mutual. It would be contrary to this scheme and contrary to what the parties must have taken to have intended if a defendant were entitled to deduct management fees for a different period.
Yeah.
And what he then decides at the end is to make an order to pay, requiring defendant to pay the sums which were plainly due. That's at paragraph 45, page 21. And he says at paragraph 53 on page 23, in my judgment, therefore, claimant's entitled to an interim payment in the sum of £75,801.62. I may come back to that figure a bit later, and that was the figure that was ordered. And you'll see the order of Deputy Master Smith, supplemental bundle divider 1, page 1, the only page. That was the.
Sorry, where are you now?
So supplemental bundle divider 1, the only page. That just to see how the outcome of the application of a summary judgment or an interim payment.
Right.
Now, going back to the position before proceedings were issued, Christo continued to deny that anything was due to Docklock. And so on the 8th of June 2018, Docklock issued this claim, which is a core bundle divider 11. Paragraph 1 of the claim form, it's sort of an account for the relevant period.
Yes.
Christo's defense...
Sorry, is it for the relevant period? Well, the first part says an account of all sums held at the 1st of October 2014.
Yes, my lord, I see that.
I mean, but what follows is for the relevant period between the 1st of October 2014 and the 1st of September 2016, but it seems to have included a claim for what was or might have been due at the 1st of October.
Well, my lord, as every lordship has noticed something which I think wasn't focused on previously, maybe my learned friend can enlighten the court as to how far that formulation of a wording in the claim form was considered in the proceedings. But
I don't think this is going to matter at all, Mr. Lightner, but you see the same in the prayer at page 165, in paragraph 3 of the prayer.
yes. I note that, my lord. If to the extent it's relevant, no doubt we'll we'll try and see if
I dare say it isn't at all. But
we can usefully add about that. But it's my lord, a well-noticed point. Christo's defence was dated the 20th of August 2018. That's at core bundle divider 12, and it contained a summary account at pages 175 to 176 of a bundle. 2 pages. Spreadsheet, table, and it showed it as entitled to deduct management and other fees totaling 544,000. You'll see that on page 176. Total payments due and owing to the defendant, of which £268,053.49 were claimed for the relevant period. You'll see that at the top. Christo Co management fees, 175,000 odd. Christo Co professional fees, 92,000 odd. And you see management fees there, first 10/14 to 1/9/16. It also claimed other management fees in respect of other periods, periods before and after the relevant period. So the result of all these figures is that Christo claimed that the final balance was actually 186,000 odd in its favour. Now, Docklock sought partial summary judgment on the basis that Christo claimed to be entitled to deduct fees for a period outside the relevant period. And without these deductions, a balance will be due to Docklock. That was the application which Deputy Master Smith heard, and on the 17th of May 2019, as we've seen, he held that under the terms of a Moylan order and the MWIA, Christo was not entitled to claim fees outside the relevant period, and so he ordered Christo to make an interim payment of £75,000 odd. Now, following this, Docklock amended its particular claim on the 22nd of January 2020, and Christo amended its defence on the 20th of February 2020, and those amended pleadings are at dividers 13 and 14 of the core bundle. Now, Christo's revised summary account is at divider 14, page 217 to 218. And you'll see from page 218 that it shows the only sum owing is that already paid out by way of interim payment. That's the £75,000 odd. You'll see the 186,000 had been crossed out, or the amount due to it would have been crossed out, and now there's a final balance owed to Docklock of £75,801.62.
So the management fees that had been in there for 2012 to the 30th of September 2014 and for 2016 after the 1st of September have come out.
Yeah, they've been crossed out here.
But you've...
And hence the 544 figure is now 282.
Yes, I see.
Now, on the 17th of November 2020, Docklock had served a Scotch schedule, which set out its case as to the sums due to it on the account. The final iteration of Christo's Scotch schedule was served on the 4th of December 2020. That was after commencement of the trial window.
Sorry, that was 4th
of December 2020. And that was the first time Christo acknowledged a liability to Docklock beyond the 75,000 odd, which had been ordered by Deputy Master Smith. The trial of a claim took place in late December 2020 and early January 2021, and on the 19th of February 2021, the first judgment was handed down, by which Christo was held liable to pay Docklock £282,372. The judge identified specific issues on which the parties might make further submissions, which led to a second judgment, which was handed down on the 26th of May 2021, by which the amount for which Christo was liable was increased to £226.18. You can see that from the order, which is the core bundle, divider 7, page 57. And you'll see there in the preamble.
I think you just said, did you, the second judgment was May 21?
Yes.
Why was there no order until January 23?
My Lord, there were a couple of applications made under the barrel jurisdiction, which right. Led to this order itself dealt with issues such as costs.
Yeah.
It also records that the defendant paid the claimant on the 8th of December 2022 the sum of 366,000 odd. That's the 291,000 odd which I mentioned before, plus interest 75,000 odd.
Yeah. One other point, I mean, it's water under the bridge because Lady Justice Falk extended your time for appealing. The time for appeal runs from the hand down of a judgment, not the making of the order. So actually, your appeal against the first judgment is 2 years out of time, approximately. Not a few days as Lady Justice Falk ruled. Unless Mr Justice Leach made an order adjourning the hand down hearing.
I understand there was an order made postponing the time for
there was, right. I don't think it's in our bundles.
No, my Lord, it's not in the bundle, no. I don't know, it should hopefully be common ground that was the.
It is. We had taken that into account. Mr.
There was an
Mrs.
order which adjourned.
There was an order which extended time for the handing down.
All right, thank you.
Now, so my lord, there was a consequential hearing on the 7th and 15th February 2022, and the payment was made by Christo on the 8th of December 2022, as recorded at first page of the order, which I've taken your lordship to at page 57 of the call bundle.
Yeah.
Now, moving on now to the accounting exercise, if I may. As a result of the Moylan order and the MWIA, Mutual Waivers Agreement, the account to which Docklock was entitled was in respect of rents, which Christo received between the 1st of October 2014 and the 1st of September 2016, what I described as a relevant period, which Christo had not already paid or otherwise accounted for. The basis for the account which the judge took were contemporaneous rental income and expenditure statements, or REIS, which Christo had prepared. And if I can just take your lordship to an example of that, it's at Supplemental Bundle Divider 11, page 213. We have to turn it to on the side to view it. It's Christo Co rental income and expenditure statement, client Docklock Ltd, sets out then the properties and then the period 1st of July 2014 to 30th September 2014. That's on the first page, page 213. And over the page, date of preparation you can see on the right, on the top right, is the 12th of November 2014. My lord, I was getting the opportunity to catch up. So I'm on page 214 now.
Yeah.
And you'll see that the first section, beginning on the second page here, contains an overall account for the period. It shows the balance brought forward, here £73,897.20. The total received, here £413,062.47. Total disbursements, here £103,075.29. And various other specific receipts and payments. And the closing balance for the period is here £148,926.56. And that closing balance can be seen as the opening balance for the next period. If we go to divider 12, page 268, that's the opening balance for the period 1st of October 2014 to the 31st of December 2014. Now if we go back to page 214, please, the last three debit entries above balance retained are the first disbursements.
They're in October, 7th, 8th and 24th of October.
Yes, my lord.
But this is said to be a statement for the period to 30th of September.
Indeed, my lord.
So they shouldn't really have appeared.
Well, they Christo Co put them in this statement.
But that means the balance of 148,926.56 is calculated not as at the 30th of September, but as at the 24th of October, doesn't it?
Yeah, my lord, or as at 12th of November, yes. Certainly not as at 30th September, yes.
So when it says on page 268, the balance brought forward is 148,926.56, that has already taken into account the first three disbursements, is it not?
Well, that appears to be the case, yes, my lord.
Well, how can they be taken into account again? Which is your case.
The figure which the judge used at trial was not actually the 148 figure. It was a different figure of $134,000 odd.
Yes, I was going to ask you about that because I haven't managed to understand how that figure arises. The defendant's Scott schedule says it's all explained in a spreadsheet, but I don't think we've got the spreadsheet.
Yes, the defendant's position was that the figure as at the 1st of October was £134,018.72, and that was a figure which Docklock at trial accepted.
So the figure that for which Christo was contending was a figure that was lower than the 148.
Yes, my lord. They said it was lower than this.
So unless there's some particular explanation, one would have assumed that the three disbursements were in the calculation which made up that lower sitting balance.
Which I don't know if I can assist. The reason that figure was lower is because it took out of account from this REIS income that had been received after the 1st of October. So in fact it worked back from this REIS to the 1st of October because this REIS was prepared on the 12th of November 2014, so it included income that had been received prior. We increased our figure for income.
So this REIT is not in fact what it purports to be. It's not a statement of account as at the 30th of September.
Was it? No.
Because it takes into account monies received after that date, and it also takes into account disbursements made after that date.
Yes.
So, I mean, the question is whether the sitting balance, as found by the judge, in fact, as appears to have been common ground by the time of the end of the trial, did that or did that not take account of the three disputed disbursements?
No, it did not.
Well, where is the...
As a matter of fact, because what happened, in terms of the evidence, Mr Forrester's evidence, calculated the balance as at 1st of October. So he looked at the income that had been received after the 1st of October, the income that had been received before, and he only made deductions that had been and then he applied the deductions that had arisen, those three deductions.
And is that what would have been shown in your spreadsheet?
Your worship, yes. Our spreadsheet worked back to the 1st of October, simply to calculate the sitting balance.
I think it might be helpful if we saw it. But I couldn't find it in the Scott schedule, but it may be there and I've missed it. But
I don't think we have that, the schedule that was appended to Mr Forrester's evidence. Here, the sitting balance represented all the money received up to the 1st of October and all the deductions that had been made up to that. And then after that, the increased figure for income, 198,000, was all the rents received after that, and then the deductions that had been made chronologically after the 1st of October were applied. So it is the case that the deductions were applied to the 198,000, so income received after the 1st of October, and were not within the 134,000 sitting balance. That's what Leach found, as a matter of fact, by accepting Mr Forrester's evidence.
So the simple position is that if we look at page 214, although it nominally shows the position up to the 30th of September, to some degree it takes into account later events, both in relation to payments out and in relation to payments in.
Your Lordship, that's absolutely right. And what Mr Forrester has done was unwind that petition, take it back to the 1st of October, establish what the sitting balance was there at that point, which necessarily took into account only deductions up to that point, and then start from the 1st of October with the income received after that date and then the deductions that were made after that date. And that's fundamentally what the judge accepted, and that was the account which he carried out.
I'm grateful to Mr Letman for his assistance on that. What I was seeking to do at this point was just to walk through one of these resits to see what exercise was carried out. Following the overall account, which we've seen at page 214, there are then a series of pages showing income from specific properties. So, for example, at page 215, it's in respect of 186 Camden High Street. At page 216, it's 7 Charlton Street, and at page 217 is 130 Charlton Street. And after that, and a few more properties, there are a series of pages showing expenditure for specific properties. For example, if you go to page 242, you will see expenditure in respect of 186 Camden High Street. At page 243, you'll see 37 Charlton Street, and 244 you'll see 130 Charlton Street. The resits were prepared for each quarter. The resits covering the start of the relevant period is at supplemental bundle divider 12, and the resit in respect of the end of the relevant period is at divider 14 of the supplemental bundle. The parties then prepared a Scotch schedule to set out their position on the account. In this document, Docklock's figures were taken from the accounts which Christo had provided to it. To the extent that Christo disputed figures for receipts, it did so on the basis of underlying information on its systems, which were never provided to Docklock. If we go now to the Scotch schedule, supplemental bundle divider 5, page 47 is the first page, but for relevant for this appeal, we go to page 51, it's paragraph 1.5, schedule the sitting balance held by defendant on claimant's behalf as at 1st October 2014. And you'll see Docklock maintained that the figure was 148,000 odd, figure found carried forward in the res that we've seen. Christo asserted that the figure was in fact 134,000 odd, and you'll see Andy's response. It said it denied these monies were monies received as agent in respect of the relevant period, says to come within the scope of the account. So they said in any event the figure was actually 134,000. See attached Excel sheet, which, as I said, is not in the bundle.
And that's the figure or the calculation which the judge accepted.
And which Docklock accepted at trial.
Yeah.
Yes, it will.
So it would be useful to know how that was made up.
Yes, well, we hear you on that. Now, Docklock made clear that it did not claim the sitting balance as such. Instead, it asserted that transfers out during the relevant period should be reduced by the amount of the sitting balance as a matter of normal accounting practice. In other words, by reason of the rule in Clayton's case. You could see that if you go to page 81 here. And at footnote 17. It says the first £148,926.56 of that amount would, as a matter of normal accounting practice, reduce the sitting balance of 148,000 odd, and subsequent sums would have been paid from rent collected during the relevant period. For this reason, the amount that the defendant seeks to reduce the income for the relevant period from its in the appendices to the amended defence is overstated by that amount. Now, if we go to paragraph 2.4, which is at page 56, you can see that the sum of £64,127, which had been deducted on the 30th of January 2015 in respect of staff salaries, was a disputed sum.
Sorry, I haven't kept up with you. Where are you?
So at page 56, my lord.
Yes.
This was in respect of the alternative
yes.
appeal on staff salary. And the parties' respective positions were set out in that schedule. Now, if you go to page 79, there's at 6.2 is a schedule of transfers from Christo to Docklock during the relevant period. And if you go over the page, you can see that the total amount there is 1,420,000. Now, a final table of account is at page 81, pages 81 to 83. And you can see from that, at page 82, under the heading of accepted disbursements, Christo, I should say in red, is the entries of Christo. So it sought to bring into the account, under accepted disbursements, the 21,519 supplier payment and the 31,864.96 pounds HMRC payment, which was made in a relevant period, but had been included in the REIS for the earlier period, as we saw. The HMRC payment is one of the three first disbursements for the purpose of this appeal. And under remaining transfers to Docklock, which is at page 83, top of the page, there are the 1.42 million, but also the 80,000 and 50,000 payments, which were made in the relevant period, but had been included in the REIS for the earlier period. So if we add them together, 1.42 plus the 80 and 50, that comes to £1,550,000. So the judge's account was summarised in table form in an appendix at the end of his judgment. We can go to that core bundle, please, divider 9. And at the end of his judgment, so it's at pages 143 and 144. Appendix to the account. So, although some of these figures were later revised, that is of no relevance to this appeal. Now, one should note the following. The monies received, 3.268 million odd, less transfers by Christo Co to Docklock, that's the 1,550,000 that I mentioned just now. That's the 1,420,000 plus the 80,000 and the 50,000. And then management fees is 87,000 odd. That includes the 64,000 odd paid to Christo as staff salaries. I'll come to that in a second, and I'll also point out the VAT payment made on the 7th of October 2014 is an additional deduction of 31,864. Now, the question of how that 87,000 odd figure was reached can be answered as follows. If you go to paragraph 138 of the judgment, which is at page 116 and 117, the judge says this: based on the findings I've made in relation to management and professional fees and the occupation charge, I find that Christo is entitled to charge Docklock 224,000 odd in professional fees, less 122,000 odd for the occupation charge and 14,000 odd for service charges, which produce a net figure of 87,224 odd, which is a figure in the account. Now, the professional fees figure, which is the 224 odd thousand, that is made up. First of all, it's all dealt with in the section of a judgment starting at page 89 of the bundle, Para 75, top of Para 75, management and professional fees. And that figure of 224,000 is made up as follows. One goes to paragraph 119.
Sorry, where are we? Paragraph 119.
Yes, my lord. That is letting and renewal fees, 149,000 odd. Then one goes on to paragraph 121, staff salaries, 64,127. Paragraph 122, next same page, is £9,120 VAT returns, and then go to 125 is 1,800 quantum merit respective rent review, and paragraph 126 there's £183 for gas safety fees. So paragraph 126 he says, after adding these fees I award Christo management fees of 224,000 odd in total. So that's how the 224,000 figure is made up. Now, if I now move on then to what Docklock's position is with respect to the appropriation question, first ground of the appeal. Now, Docklock's position is straightforward. It can be stated as follows. The account between Docklock and Christo was a running account. In the case of a running account, a payment out of the account is appropriated to the earliest sum paid in. The first in, first out principle, or the rule in Clayton's case. Accordingly, when Christo made the payments to HMRC of £31,864.97 on the 7th of October 2014, and to Docklock of £80,000 on the 8th of October 2014, and £50,000 on the 24th of October 2014, these were all appropriated, in the last case pro tanto, to the sitting balance of £130,118.72 due from Christo to Docklock as at the 1st of October 2014, which represented the earliest sums which Christo had received and not to any sums which it received after the 1st of October 2014. That appropriation either took place on the date of the payments themselves or on the date that the third quarter 2014 REIS was produced, namely the 12th of November 2014, as we saw. In either case, that appropriation had taken place long before the making of the Moylan order. Accordingly, the judge ought not to have brought the first disbursements which were appropriated to that sitting balance into the account. As well as being contrary to authority, the judge's decision results in an unfair and unjust windfall to Christo and subverts the purpose of the exception which Mr. Justice Moylan ordered in the first place for the following reasons. It gives rise to double counting. Christo had already deducted the first disbursements from a sitting balance, which it held on trust for Docklock on the 1st of October 2014.
You're going to come back to that.
But that point, yes.
Yes.
The judge allowed Christo to deduct them again from rents received during the relevant period. The same disbursements were therefore debited twice from Docklock's account.
If you're not going to expand on that, I'd like to understand it better.
Yes. Well, the money which was received during the relevant period and before was held by Christo on trust for Docklock. And Christo had no entitlement to retain it. However, by holding it, Christo could set off against that liability to Docklock the first disbursements which had already been paid out of other funds to which Docklock had also been entitled, the judge allowed Christo to obtain that money to which it never had any entitlement.
Well, there was a waiver of claims up to the 1st of October 2014. So that, is this right? That would have released Christo from any continuing duty to account for monies held at that date.
Well, what we say is that the purpose of the exception which Mr Justice Moylan
Well,
ordered...
what's the answer to my question? What's the waiver? Full and final settlement. So that's the end of Christo's obligation to account for what it had on the 1st of October, isn't it?
Well, what we say is it doesn't affect prior conduct of the parties in terms of appropriation. If there's been a prior appropriation and prior dealings in a running account, then that is not disturbed by that order. That's what we say. I'll try and elaborate on that a bit more in court.
Is this, so to speak, in summary, you lost any right to claim in respect of rents received before the 1st of October? On your case, there were no relevant rents, because although at the 1st of October, if you took a snapshot, a sum was due to you in respect of rents, long before Mr Justice Moylan made his order,
Yes.
that liability had gone.
Precisely. And that the order of Mr Justice Moylan did not retrospectively overturn or change what had already happened.
Just reversing for a moment, I'm afraid I don't understand the double counting point. I quite see that you say, well, I quite see the way you put it, which I was trying to reflect a moment ago.
Yes.
But where does the double counting come in? Those payments haven't hitherto been taken into account, have they?
Well, what we say, what the judge allowed was to Christo to bring into account payments which had in fact discharged its liability to account for earlier receipts.
Yes, I see. So there's no double counting on the judge's view of the thing.
No.
But on your view of the thing, there is double counting.
Yes.
Yes, I see.
Now,
Does that assume that the payments were taken into account in calculating the sitting balance, or not? Does it not matter?
no, my lord, they weren't.
And yes, I mean, in effect, it was your case at trial that they should be taken into account in arriving at the relevant figure.
Yes.
But that was the case that the judge rejected.
Yes.
The judge would have been right if the sitting balance was treated as nil at the 1st of October.
Sorry, treated as a...
As nil at the 1st of October.
Incorrect, yes, my lord.
So, is the question this: when Mr Justice Moylan makes an order, Lord Justice Moylan, as he then was, saying you can have an account of rents received from 1st of October, is that intending to start again as if there was nothing due to you, no sitting balance on the 1st of October? Or was it not intended to disturb the actual position under which there was it's admitted there was 130,000 owing as at the 1st of October? It was, how do you start the account? So,
Well, also, we say it wasn't intended to disturb any previous appropriations. So it's not starting. It's not starting afresh in that sense.
You say that's so as a matter of interpretation of the order.
Well, we say that that's so as a matter of how a running account operates.
I know, but
there was nothing in the
but
order.
the question is then, was it the same running account before and after the 1st of October, or is the effect of the Moylan order to create a new running account, which, as my Lord Justice Nugee says, starts as if there were no sitting balance? I mean, that's a question, and that may depend on how you interpret the order.
Yes.
I mean, if there was a single running account which persisted all the way through from whenever it started until the end of September 2016, then no doubt you're right that Clayton's case would apply. But the question is, has that in some way been changed by the waiver in full and final, and underline the word final settlement, plus the Moylan order ordering an account to be taken starting on the 1st of October?
What we say is that there's nothing in the Moylan order or the WCIA which has the effect, either expressly or impliedly, of disturbing retrospectively the appropriation of the first disbursements. And what we say is there's no wording which has that effect. And we say it would be wrong to interpret the Moylan order or the WCIA in such a way as to give a new right on the part of Christo to retain money for which it had already duly accounted.
I mean, the order doesn't actually direct an account at all. What it does is say that you can still pursue a claim for rents received after a certain date. And it also contemplates that that claim could be defeated insofar as Christo can say that it's accounted for those rents or paid over sums in that way. So to speak, on your view of the world, it doesn't say we'll start a new account. It just says you can still claim for rent received after a certain date, and you deduct from that insofar as payments have been made that are attributable, properly appropriated to those rents.
Yes, from that date. And what we say is that the reason for the carve-out in respect to the relevant period was a concern that Christo had manipulated the company's finances by failing to account for rent received. I was going to go on to talk about the question of a running account, unless your Lordship would like me to address any of these issues now. We'll come back to them a bit later. Docklock submits it's clear from the Reeses that this was a running account, and this can be seen from the judgment of Lord Justice Kitchen, with whom Lord Justices Christopher Clark and Laws agreed in W.H. Smith and 20th Century Fox. That's at the, you can go to the authorities bundle, please. Divider 3. Or divider 4. And I'd just like to take your Lordships to...
Your Lordships, I don't know if it assists my friend or the argument.
Sorry?
I don't know if it assists my friend or the argument, but I accept the underlying, the Reeses in themselves represented a running account. But that's not what was required under the Moylan order. There was a break, if you will, in that running account. So I quite accept that the underlying account. Just, well, I will present my submissions now, but just Lord
Yeah,
Newey has
all right.
pointed
Well,
out.
let Mr Lightman develop his point, and you can either agree with it or not agree with it, as the case may be.
Well, I may take a little bit more quickly, but I do want to point out this was a running account. Paragraph 33, for judgment, if I go to page 82 of the photo bundle. The parties agree in the case where transactions between parties are recorded in a running account, these transactions are not treated separately for accounting purposes. As Mr Justice Millett explained, in such case they are not mutual but independent obligations, capable of being quantified and set off against each other, but rather reciprocal obligations giving rise to credits and debits in a single running account, so giving rise to a single liability to pay the ultimate balance found due upon taking the account. And if I go down to paragraph 34, transactions between two parties may be recorded in a running account in a great variety of relationships, but it is characteristic of them all that the parties have expressly or impliedly agreed that the monetary outcome of each transaction shall not be settled separately. In Rolls-Razor, Lord Justice Wynne put it this way: when dealings are mutual within the meaning of a section, the Bankruptcy Act, Section 31 of the Bankruptcy Act 1914, appears to be determined by the intention of the parties from these dealings expressed to each other or to be inferred from the character of the dealings. Thus, the relationship of banker and customer on a current account implies from its very nature an intention on the part of both parties that debits and credits arising between them shall be brought into a running account upon which, by reason of the customary method of keeping such account, there will at any given moment be an outstanding debit or credit balance. Similarly, producers of such commodities as fruit and vegetables, who market them through selling agents in, for example, Covent Garden, normally, if not necessarily, deal with these selling agents upon a running account in which credits in their favour will arise in respect of proceeds of sales received by the agents, with related debits for commissions and sale expenses incurred by the agents in disposing of the goods or making allowance for quality deficiencies. These are only examples which could be almost indefinitely multiplied by taking into consideration such other relationships as those of a landlord and his rent collectors. And the contrast is then drawn with dealings of a kind which may occur even in isolation or within a complex of a continuous range of dealings which are themselves mutual, or such a kind it's clear from their character that the parties intend that the monetary outcome of them shall be separately settled between the parties and not treated as a mere item on one side or other of the running account. And it's much the same point, paragraph 35, emerges from the position of Australian High Court in the Air Services Australia case. If we go over a page, where it says, in the course of their judgment, Dawson, Gaudron and McHugh, JJ, explained the nature of a running account in these terms. Going down 7 or 8 lines, a running account between traders is merely another name for an active account running from day to day, as opposed to an account where further debits are not contemplated. The essential feature of a running account is that it predicates a continuing relationship of debtor and creditor, with an expectation that further debits and credits will be recorded. Ordinarily, a payment, although often matching an earlier debit, is credited against a balance owing in the account. Thus, a running balance is contrasted with an account where the expectation is the next entry will be a credit entry that will close the account by recording the payment of the debt or by transferring the debit to the bad or doubtful debt account. Now, we turn now to the Reeses. It's clear that they're drawn as a running account for the following reasons. First, there is a single account between the parties. The state of this single account was communicated by Christo to Docklock through the Reeses. Secondly, there's no attempt to settle individual transactions separately. Thirdly, the Reeses do not identify specific amounts due from Christo to Docklock in respect of specific rent received or payments made by
Sorry,
Christo.
I wasn't keeping up.
Sorry.
Your third point was?
The Reeses do not identify specific amounts due from Christo to Docklock in respect of specific rent received or payments made by Christo as individual debts due one way or the other. Instead, they contain an opening balance, a summary of receipts and payments for the period, and a closing balance. Fourthly, the sum due from Christo to Docklock is simply the closing balance at any given time, the releases being no more than quarterly snapshots. Fifthly, there's clearly no intention that this closing balance should be matched in each case by a corresponding payment out by Christo to bring the balance to nil, that is until the end of the relationship. And this can be contrasted with the position as was found in the W.H. Smith case. There it was held that there was no running account because each party held a separate ledger on which it relied. Those ledgers were, at least in part, based on documents which were not accepted by the other party as contractual documents. We can see that from paragraph 40 of that judgment, page 87. Divider 4. Which is right, invite the Lordships to read that paragraph. Yeah. Now we say none of these considerations apply here. In addition, in that case, the contractual relationship required Fox to settle any balance due to W.H. Smith within 14 days. There was no agreement that W.H. Smith would extend credit in respect to sums due until they were brought into the account. You can see that at paragraph 41. At the top of page 88. There was no agreement that W.H. Smith would generally extend credit in respect to sums due until they be brought into account. To the contrary, if the return of goods put Fox into a debit position and W.H. Smith was unable to deduct the balance from the payment due, it required settlement within 14 days. Similarly, it required settlement of invoices in respect to the services it provided. Again, there's no equivalent in the relationship between Docklock and Christo. And the present case can also be contrasted with the position in Mecca, which is at Authorities Bundle divided 2, where there was no current account, or indeed any statement of account, at the time of the payment which it was sought to attribute. The House of Lords held that there were simply two separate transactions, later recorded on a single piece of paper. And if we can go to the head note there, just take you to some of that head note, page 37. In April 1894, the appellants were the holders of 4 dishonoured bills of exchange. Going down a few lines, the first bill, due April 7, was for £267 odd on account of the Medina. The second, due April 26, for £176 odd on account of the Mecca. Yet the other two both fell due on the 27th of the same month. One was for £194 odd on account of Mecca, and one for £630 on account of the Medina. Just go over the page. On August the 15th, 1894, the sum of £900 was accordingly paid to the appellants by H.E. Moss & Co. Going down a few lines, on 22nd of August, a letter was written on behalf of the appellants to the manager of the company acknowledging a receipt of £900. The writer expressed a hope that it was the company's intention to remit at once the balance due, namely said £401 odd as per statement herewith, and thus obviate the necessity of our taking further steps. To secure it, the statement which accompanied the letter was headed, and you'll see the heading, There followed particulars of the 4 bills with notarized expenses added. I just invite you to read the rest of that paragraph. And if one goes then to the judgment of Lord Halsbury, starts at page 41. And if I could invite you, it's a 1.5 pages, I invite your lordships to read that judgment. And in particular, 3 lines down on page 42, this is not an account current. There is no setting one item against another. Credit is given for the £900 at the end of all the items. They're all separate transactions, and although one piece of paper seem to represent only historically the transactions as they occurred. And if we can again go on to Lord Herschel's judgment.
Can we just go back a page?
Yes.
Having set out what was decided in Clayton's case, Lord Halsbury goes on to say that it's not a rule of law, not an invariable rule of law, but the circumstances of a case may afford ground for inferring transactions of the parties were not so intended as to come under this general rule. And that, I think, is the argument against you, that by the mutual waiver agreement and the Moylan order, it was no longer a running account to which the principle in Clayton's case applied. That's the argument against you.
That seems to be the argument, yes, my lord. What we would say is that doesn't have the effect of retrospectively affecting what had happened 3 or more years earlier. We had understood we were meeting a case of it not of being disputed as to whether it was a running account in the first place, but I want, if I can just try and establish, first of all, it was a running account, that the authorities, which seem to be considered and relied on by the other side, or which may be pertinent to throw light on the application of the Clayton's case rule, don't apply to our case, certainly at the outset. Then we can see what if anything, happens subsequently to retrospectively disturb what we say happened. And so that's Lord Halsbury's judgment. Lord Herschel, again, if I could just take your lordships to page 43, starting, I think, if I could start, ask your lordships to read the passage which is highlighted.
Yes.
And I just highlight so I don't have to come back to it, my lord. He does say that it was there decided, as is in Clayton's case, that where there is a current account between parties and payments are made without appropriation of them, they are to be attributed in point of law to the earliest items in the account. On the facts of that particular case and the observations which were made there, it was held that Clayton's case, the rule in Clayton's case, didn't apply. But we say none of those observations are pertinent in this case. The system by which Christo provided an account for Docklock quarterly in the Reese format was precisely that of bringing receipts and payments into a common account. And we can go to the judge's judgment.
Just before we leave the Mecca, could we have a look at Lord Macnaghten's speech?
Yes.
On page 294, page 45 of our bundle, between the two hole punches, he talks about Clayton's case, and he says Clayton had a current account. The customer's account was kept from first to last as one unbroken account, and then he recites some more of the facts. Then he refers to what the Master of the Rolls said. He distinguished the case from authorities which had been cited in favour of the claimant by saying they were all cases of distinct insulated debts between which a plain line of separation could be drawn. And then a couple of pages further on, page 295, bottom of our page 46, he refers to Hallett's case and what Sir George Jessel had to say about Clayton's case. It's a very convenient rule. Nothing to say against it unless there is evidence either of agreement to the contrary or of circumstances from which a contrary intention must be presumed, and then what is a mere presumption is those other considerations.
Yes, and he says also at page 295, page 46 of the bundle, the facts of the present case are very different. There's no
yes, indeed. Oh, yes, absolutely. He finds there's no running account, but I think the thrust of what he's saying is even if there is a running account, Clayton's case is a question of intention, and it can be displaced either by agreement to the contrary or circumstances. And that was the case in Hallett, wasn't it, where the trustee took money out, and it was said, well, the trustee takes his own money out before he takes the beneficiaries.
I agree, my lord. It does. The authorities do talk of either agreement to the contrary or circumstances in which a contrary intention must be presumed. What we say is that is as at the relevant date. That at that time, rather than
Back to the retrospectivity.
Yes, yes, my lord. Yes, we're not challenging that it is. It does apply subject to. Well, I think it's put. I think by. As Lord Herschel said, it's not an invariable rule of law,
Yeah.
which is at page 41. But the circumstances of the case may afford ground for inferring the transactions of the parties were not so intended as to come with under that general rule, which is page 41.
Yeah.
So look at it pre-Moylan order, if you like, my lord. We can go to the judgment itself here, core bundle, divider 9. Paragraph 38 of the judgment, which is at page 76. Paragraph 38, bottom of the page. Mr. Forrester explained that the releases were fundamental to the management of a client's property portfolio. They showed all the income received, what expenditure had been incurred, including any fees charged by Christo, and the balance held by Christo at the end of any quarter. He also explained that it would take on average 4 or 5 weeks for the period to be closed and the release submitted to the client. In practice, therefore, the account took the form of Docklock, challenging individual entries in the releases submitted by Christo for a relevant period, and Christo defending them. Now, Lord, 2 further points arise. First, Christo does not say that there was no running account between it and Docklock at the beginning of the relevant period. Its only argument on this point is that the account to be taken by the judge was not a running account. We say that proposition is not correct. It focuses on the wrong thing. The identification of a running account depends on the account as kept between the parties and not the account to be taken by the court. As Lord Herschel said in the passage from Mecca that I took your lordships to at 292, it was there, i.e. in Clayton's case, decided that where there is a current account between the parties and payments are made without appropriation of them, they are to be attributed in point of law to the earliest items in the account. And secondly, this question should not arise. The judge did not hold that the account was not a running account. We go to paragraph 62 of his judgment, page 86. It's not entirely clear, but it appears that the judge considered that it was a running account, that the rule in Clayton's case was disapplied by the Moylan order. Now, the rule in Clayton's case is straightforward to state. In the case of a running account, a payment out of the account is appropriated to the earliest sum paid in, the first in, first out principle. And this is clearly set out in Clayton's case, as Lord Justice Dillon explained and approved in the Barlow-Clowes case, which I'd like to take your lordships to. It's at Authorities Bundle Divider 3. Page 28, so that's page 56 of the bundle. And if I could invite your lordships to read the passage highlighted from Clayton's case on the top of page 28 until the end of the first paragraph on page 29. Now, I intend to look at Barlow-Clowes in a little more detail shortly, but just to highlight at this point, the Sir William Grant, Master Rolls, says at between F and G on page 56, in such a case there's no room for any other appropriation than that which arises from the order in which the receipts and payments take place and are carried into the account. Presumably it is the sum first paid in that is first drawn out. It is the first item on the debit side of the account that is discharged or reduced by the first item on the credit side. The appropriation is made by the very act of setting the two items against each other. And so that's the appropriation takes place either at the time of payment or at the very latest at the time when the statement of account is delivered, we say. And bottom of the page, Lord Justice Dillon says, the rule will apply to the appropriation of payments made between any trader and his customer, whether there's an account current or running account, but it doesn't apply unless there's a running account, and as we've seen in respect of the Mecca case, Lord Halsbury said, it's not an invariable rule. Circumstances of the case may afford ground for inferring that transactions of the parties were not so intended as to come under this general rule. And again, on the same point, if we can go to the W.H. Smith case we saw before, page 84, paragraph 35, a quote from Airspaces Australia, what we saw before. It says, halfway down the page, ordinarily a payment, though often matching an earlier debit, is credited against the balance owing in the account. That's stated to be the effect of a running account. Now, Christo seeks to rely on two authorities for the proposition that the rule in Chris Clayton's case should be disapplied. Of these authorities, the Mecca is not an example of a rule being negatived. The House of Lords decided that the rule was never engaged because there was no running account, as we've seen. Barlow Clowes is an example of the rule being disapplied, but it's important to understand why. And the factual background is important and can be seen from a headnote. We can go to the headnote of the Barlow Clowes case. Divider 3, page 50 of the authorities Barlow. And if I can just invite your lordships to read from D until H.
Yes.
So there was a dispute between what were described as the late investors and the early investors. The early investors contending that the first in, first out rule should not apply, and the late investors saying that it should. Now, if one goes to the reasoning of the three Court of Appeal judges who each gave separate judgments, now go to page 29A of the actual report, page 29A. As we saw before, Lord Justice Dillon said the rule in Clayton's case doesn't apply where it can be inferred that transactions of the parties were not intended to come under the general rule. He went on to find, to go to page 31B, said that the gilt-edged investments actually acquired by BCI, which are part of the additional assets, were lawfully investments of investors' monies as part of a common fund and not to be allocated under the arrangements to individual investors. It would consequently be contrary to the intention of the original arrangements to trace through under Clayton's case the monies actually applied in the purchase of these gilts, so as to allocate them to individual investors. And he then goes on at 31G to say that with respect to the uninvested monies held by Barlow Clowes, that's at F, but the question posed by Lord Halsbury in the Mecca must be answered by considering the nature of the transaction as the investors intended to be at the outset when they paid their monies to BCI, not for various different circumstances of the actual outcome of which they contributed, when they contributed they knew nothing. He then concluded the monies in the bank accounts in Schedule A ought to be treated for the purpose of distribution as the uninvested part of the common investment fund. And he says at H, that assets bought through misapplication of trust monies were misapplications of this common fund. So again, the rule should not apply.
Sorry, where is that?
That's at in H and J.
I see, yes.
And at 33 G to H. He was rejected for what he called Mr. Walker's wider submission. Now that wider submission was that a rule applied to the parties to a running account, such as a banker and customer, and not to resolving conflicting claims by beneficiaries to trust monies. He rejected that submission. You can see he summarised it at 31J to 32A, by bottom of the page, Mr. Walker's wider submission.
Can I just ask, what is the North American method?
It was, yes, that was seen as totally impractical in this case. I
think it's page 27.
Yes, my lord. Yes, thank you, my lord. It's called a rolling charge or North American method.
Yes.
It's explained a bit more on top of
Right.
28 also. It was found to be impractical and not a realistic option. And so the widest submission, as I say, was summarised at 31J and 32A. It was also summarised by Lord Justice Wolfe at 36D, if you just wanted to see how he put it, how this submission was summarised by him. He describes it at 36D as, the wider argument is that rule in Clayton's case is concerned with resolving the rights of a banker and his customer to the funds in the bank account and not resolving the conflicting claims.
Where are you, Mr. Lutton?
So that's at 36D. That's the judgment of Lord Justice Wolfe. Page 64, page 36 of the report.
D.
I say that because he summarises there what this wider argument was in a sort of slightly more clearly understandable way. And he says that that was the argument of Mr. Walker, you see, of the wider argument. That wider argument, going back to Lord Justice Dillon, where we were before, it's rejected at 33 G to H.
Yeah.
And then moving on to Lord Justice Wolfe's own judgment. One goes to page 63, or page 35 of the report. At 35E, first of all, he quotes from C. Mr. Walker contends, in the case of his sort, the application of the Clayton rule can and would produce results of a highly arbitrary nature. And he referred to the dicta of Justice Learned Hand in re Walter J. Schmidt and Co. When a law adopts a fiction, it is, or at least should be, for some purpose of justice. To adopt the fiction of first in, first out is to apportion common misfortune through a test which has no relation whatever to the justice of the case. In my judgment, this is Lord Justice Wolfe. This comment on Lord Judge Learned Hand accurately describes the result of applying the rule in Clayton's case to the common misfortune which was shared by the investors in Barlow Clouds. He then goes on, if you go to 36H. He refers to speech of Lord Sumner in Sinclair and Brown, and picking up on that between H and J, he says, what I've already said, it'd be clear, but I regard the present claims of investors being, and quoting here from Lord Sumner, equal and for present purpose identical, is however a rule of equity, of law equity, which cannot be disregarded in relation to the assets which are involved in this appeal, which are admittedly subject to a trust in favour of some of the investors. So going back to Lord Sumner, just to sort of explain that a bit further, says in this case, neither the shareholders nor depositors have the better equity. The money of each has, with the consent of all, been indiscriminately applied in acquiring assets beyond as well as within the society's powers, form in much a larger measure. The claims of each class are equal, and I think for present purpose identical. Now, then going on to page 38J, he said, and if you just look at the highlighted passage from the bottom of page 66, end of the first paragraph of 67, he says, on authorities as they apply to innocent claimants to a trust fund, the rule can be applied, but does not have to be applied. It will only be applied when it's convenient to do so, and when its application can be said to do broad justice considering the nature of the competing claims.
I'm afraid I've lost you.
Oh, sorry.
Where is this?
So this is the top of page 39, or page 67, depending where you're looking, Lord Justice Wolf's judgment. Perhaps I'll pick it up from the beginning.
I see. Yes, I see.
This is from B and C I'm looking at here. It will only apply where it's convenient to do so, and when its application can be said to do broad justice, considering the nature of the competing claims. It is displaced where the rule would unjustly assist the trustee at the expense of the beneficiary. I'll come back to that a little bit later. And it is displaced if it's shown to be the intention of the parties. On the facts of that case, if you go on to 41, D, he says the better view is that the investments were to be made subject to a collective investment scheme, which would exclude the rule as a matter of intention.
Where are you?
So that's at 41D.
Can I ask, Mr. Lyman, what are the propositions which you invite us to take from this case? Because as I understand it, it's not disputed that before Mr. Justice Moylan's order, this was a running account, and the rule in Clayton's case did apply.
Yes.
And I think the relevant question is, what was the effect of his order on that? And we have your submission that it didn't retrospectively change the appropriations.
Yes.
Does this case assist us with
that
question?
It may not. I wanted to take your lordships through the determination on that fact. If in fact there's not a sort of serious question as to whether it was a running account to start with, what we say is that this is not a comparable case to Barlow Clouds. There weren't multiple claimants to a mixed fund. There's one claimant, Docklock, seeking payment out of its own unmixed fund. And to the extent that the rule may be disapplied on evidence of a contrary intention.
He says that again at page 42, at G.
Yes. The express or inferred or presumed intention of the investors. Yes, my lord. We say, well, that there was not put forward at trial evidence to a negative intention, but the rule should apply to the running account between Docklock and Christo. The judge wasn't asked to make those findings and did not make any such findings. The possibility of a contrary intention is not borne out by the Reeses, which do not suggest that the account between Christo and Docklock was to be treated as anything other than a usual running account. And Lord Justice Wolfe noted in the Barlow-Clowes case, a passage I just took your lordship to, the rule will be disapplied where it be unjustly assisted a trustee at the expense of the beneficiary. Here, in contrast, it's a trustee who is seeking to disapply the rule precisely so it can be unjustly assisted at the expense of its beneficiary. So we will come to the effect of the Moylan order. It's important, we say, to see, well, what was the position 3 years before that?
Well, I think Mr. Letman accepts that beforehand it was a running account. And although you're quite right to say that as Docklock's agent, Christo had fiduciary duties, the Moylan order and the mutual waiver was, to all intents and purposes, a commercially negotiated agreement to settle what appears to have been quite bitter matrimonial proceedings between Betty and Chris. And the question is, what effect did that have?
Well, what we say is that...
and as you say, well, it didn't retrospectively alter anything.
Yes,
We've got
but it may be, my lord, I don't, not much further is benefited by repetition of the point, other than to say that it's, we say, quite clear that the rule in Clayton's case applied. It was a running account, and so it was not a question of us trying to sort of recover money now. We're not trying to recover monies from outside the period. We say this happened. It's already happened.
Yeah.
I mean, the question doesn't relate to the rents that came in. The question relates to what deductions are permissible on the other side.
Yes. So we're saying this isn't an attempt by Docklock to, as the other side put it, obtain something by the back door. It's an attempt to prevent Christo obtaining an illegitimate windfall by preventing double counting of the first disbursements. That's what we say.
I still don't follow the double counting point.
Well, it's Christo's trying to bring into the account payments made out of different monies not received during the relevant period.
Well, where's the double counting? They haven't been counted otherwise.
Well, as at 1st of October 2014, Christo held a sitting balance on trust for Docklock. I think maybe the way I should put it rather than it's rather that as a matter of accounting, that those monies had already been accounted for by Christo Co. And so we're not trying to set up a new claim, if you like.
And they'd been accounted for by the production of the Reese. Is that what you say?
Well, by the manner in which the account had been conducted as per the Reeses.
And that would suggest, wouldn't it, that the sitting balance already took account of those disbursements?
Well, what I understand. Okay, the sitting balance as per the Reese that we took court to did, but the sitting balance as put to the judge did not.
Can I just see if I've got it right in this way? If you took a snapshot as at the 1st of October, Christo owed you £134,000. It may even be common ground that if you took a snapshot at the 1st of November, that had all gone. It may still be that Christo owed you money, but it wouldn't have been money in respect of the rents that had come in before the 1st of October. It would be money in respect of rents received after the 1st of October. Is that a correct understanding of your case?
Yes. Yes, yes, my lord. So I don't think it benefits from repetition.
No.
The points
So
I
is
made.
that deals with ground 1, does it?
Yes, my lord. So ground 2 I'll take shortly. On the 30th of January 2015, Christo paid itself £64,127 from the monies it was holding for Docklock. And that payment is shown on the relevant REIS. Go to supplemental bundle, divider 13, page 274. You'll see staff costs. This is the second line. Staff salaries, Docklock Ltd, salary 30th of January 2015, £64,127. And that's for the, go back to page...
Sorry, I'm not with you. Page 274.
274. Now, page 271 is the REIS for the period 1st of January 2015 to the 31st of March 2015.
Right.
If we go on to page 274...
And we've got staff salaries Docklock.
Yes.
Invoice date 30th of October 2015, 84,000 odd.
So it's 64,000 odd. It's actually 30th of January 2015. That is the staff salary.
Where's the... Oh, is that... I'm misreading it, am I?
It's a 6.
It's a 6. Yes, the type isn't very clear.
It's a bit clearer in the right-hand columns.
Oh, yes. Yep.
Yes, it looks like an 8 actually in one, but it's actually a 6. And that payment was made following a letter to Chris from Christo's accountant, Mr Petrides, of 29th of January 2015. We can see that at supplemental bundle divider 16, page 280. This is a letter from Mr Petrides, the accountant, to Mr Christoforou. I enclosed Christo's accounts for the year ended 30th April 2014. Please note the following regarding this year's accounts, and the top of page 281. As at the year end, the company was owed £64,127 by Docklock Ltd and should be settled by the latter. This relates to previous year's payroll costs charged to Docklock Ltd. So this related to a staff salary prior to the relevant period. Now, if one goes to the judge's judgment, his first judgment, he held, to divide core bundle 9, first of all, the first issue had to decide it's a power 97, page 100. He was satisfied that by January 2013 at the latest, Docklock had agreed to pay the salaries of Nicholas and Mr Forrester in lieu of management charges. And he So that then leads to a conclusion. That's at 98. Also, there's in the paragraph 101, page 102. I've no doubt he was aware that salary payments to be recorded as management charges in 2012 and 2013 accounts. And then we go to paragraph 103.
Sorry, I wasn't keeping up a bit. What was your last quotation?
This is a paragraph 101, page 102. It's not perhaps the most important citation, but I'm saying it so that the court can see the findings. The more important one perhaps is paragraph 103, page 103. I found the arrangement was the subject of all agreement between Chris and Nicholas, and they agreed that Docklock should assume the liability for salaries of Nicholas and Mr Forrester in lieu of management fees, of sufficient certainty to be enforced, so a binding contract. He then goes on to include those in a final tabulated account. If you go to page 143, that figure of £87,000 odd under management fees after set-off of occupation charge, that includes the staff salaries. We saw that when we were looking at this document before. And we'll come back to it. So paragraph 120 and 121 are the judge's reasoning on this. It's page 110. So he says on the 30th of January 2015, Mr Forrester paid a sum of 64,000 odd to Christo on behalf of Docklock in response to the letter that we saw before. And he says he found it was a contract for payment of the salaries, and the payment was made pursuant to the contract. In paragraph 121, Mr Kaminsky also challenges payment on the basis of its timing, and it related to a liability which had accrued during a financial year ended 31st March 2012. Again, I reject this submission. It was an outstanding contractual liability for which Docklock was liable to Christo, and in my judgment, Christo was entitled to use the funds which are held on account to discharge that liability. Now, we saw at paragraph 36 of his judgment of the 17th of May 2019, Deputy Master Smith had held, this is at Supplemental Bundle 2, page 17, that the effect of the Moylan order and the WCIA was that Christo could not recover management fees for any period outside the relevant period. What we say is, if the Moylan order and the WCIA did not have any retrospective effect on the categorization of payments already made, then we accept that the judge's judgment was correct. But if they did have that retrospective effect, such that the first disbursements were no longer to be treated or deemed to be appropriated to the sitting balance, then they must also have affected Christo's right to claim as a disbursement the staff salaries, as they were management fees for a period outside the relevant period. So that's our short point.
I haven't quite understood by what you mean, no retrospective effect. Can you go through that again?
If the what we say, if they didn't disturb prior categorization of payments,
yep.
Then we say the judge is entitled to come to the view he did at paragraph 121.
So if you're right on ground one,
Yes.
you don't pursue ground two.
No.
If you're wrong on ground one,
Yes.
then you do.
Indeed. So, my lord, unless I can be of assistance at this point.
Sorry, I'm so afraid I'm being obtuse. I'm not sure I have understood this alternative argument. So we suppose now that the judge was right to say, well, in effect, we start an account again with effect from the 1st of October. and on that basis, it's legitimate for Christo to claim to take into account the payments it made in October, even though at least the VAT must have related to an earlier period. Why is it not consistent with that approach to say that it's also fine to take into account this payment, although it was related to an earlier period? Because it was a payment made during the period of the new account.
On the basis of that we are wrong in our primary case, or
Assume for the moment that you're wrong on your primary case, because
Yes.
we don't need to worry about this ground if you're right on your primary case.
yes,
So if you're wrong on the primary case, in effect there's a new account taken from the 1st of October, and in the context of that account we look at what rent was received after the 1st of October, but we also look at payments out after the 1st of October.
yes,
And I don't think on that basis you dispute that it would be right to take into account, say, the payment of VAT in October, even though presumably it related to an earlier period. Well, if it's all right to take into account the payment of VAT in October, what's wrong with taking into account the payment of 64,000 in January for staff salaries from an earlier period?
because we say that. Well, we say that that's part of the prior management fees.
So it depends on the reference to management fees.
And the decision of Deputy Master Smith.
Could we just take it by stages? So what the judge ordered in his order here you say we're within the scope of B. Sorry, page 245 of the bundle. So you say that we're within the scope of B, and therefore we're only concerned with management fees for the period from the 1st of October 2014.
Yes, my lord. And so, yes, we're not talking about, for example, VAT or, liabilities or some other payment to a third party.
And is there then, I think he's put against you, well, this isn't really management fees.
That's what's said. I mean, the judge's appendix to the account talks about management fees after set-off of occupation charges. That was at page 143 of the judgment. And what...
Well, the other way it's put against you, I think, is that you can't say that if Christo have deducted the staff salaries from the rent received, that Christo has not duly accounted. That's the other way of putting it against you, I think. Because Christo has accounted for what's left after making these various deductions. Or is liable to account for what's left after making these various deductions.
But if we're wrong, if it's found against us that the impact of the order and the agreement is retrospectively to affect transactions and treatment before, we'd say it would be wrong that it should only work in one direction.
Yeah.
And why would this work? Yeah.
Yeah.
Why would it be working in more than one direction? I mean,
Because it would enable effectively Christo and Co to charge management fees in respect of a prior period.
Yes.
Yes.
Is this a waiver of claims point? Is this they had a claim already by 1st October 2014, which they've waived, so they can't bring it into account later. Is that the point?
Well, that is a way we say to put it, yes, and that's why we say it's covered by this waiver of claims at paragraph 19b. And I just think the judge, as I said, did include this in his figure of 87,000 as in management fees in his appendix to the account. So that's how the judge treated it, and that's why we say it's an inconsistency of treatment. That this
But
management,
the schedule to the order is just a brief summary. I mean, they're clearly not actually management fees. They're payments of salary, which Docklock agreed to assume liability for in lieu of management fees, and you get that from the judgment.
yes,
So it's not actually a management fee, but I think your argument is it should be treated the same way as management fees should be treated, and they're limited to management fees incurred in the relevant period, and this was incurred earlier than the relevant period. No, I think that's what you're saying.
well, maybe, my lord, that we have to put that gloss on it. It was under the general umbrella, as I say, from page 89 of the paragraph 75, page 89 of the bundle, management and professional fees, and it was treated as akin to management fees, and our position had been that it should go the same way as our arguments on the sitting balance.
Yeah.
For what it's worth, my lords, it's been pointed out to me that the judgment of Deputy Master Smith it's at supplemental bundle 2, this bundle divided 2, page 18, paragraph 37. It says the terms of paragraph 19 of the order are clear. Any claim by a defendant for management fees is limited to that period. It seems clear that there has been no claim for rent collected, management charges, which is a slightly wider expression, or an occupation charge outside that period. So, my lords, I don't know if I can assist you further on that particular point.
Right. Thank you, Mr. Lattman. Yes, Mr. Lattman.
Lords, I notice the time was, in fact, but I'm content, your lordships are content for me to start with my submissions.
Well, you might as well have 5 minutes now.
Can I therefore take you to my skills?
So you accept, is this right? You accept there was a running account,
Yes.
and you accept that the rule or principle in Clayton's case would have applied to it.
Yes.
And you say, do you, that the Moylan order and the waiver agreement changed all that?
Yes. I say.
Right.
But if I'm-
So what we need to do is to construe the Moylan order and the waiver agreement.
And the way.
Right.
Yes.
Just before you do, again, trying to understand what is and isn't in dispute. It isn't in dispute that if one took a snapshot at the 1st of October 2014, you would have owed 134,000 to Docklock.
Yes, that was the sitting balance at that time. Yes.
And it isn't in dispute either that if you had taken a snapshot at the 1st of November 2014, there would no longer have been any liability in respect of rents received before the 1st of October 2014.
I'm trying to follow if I may.
Yes,
Point.
the liability at the 1st of October 2014 related to rents received before that date.
Your Lordship, absolutely. Yes, yes.
At the time, leave aside for a moment Lord Justice Moylan's order,
Yes.
the running account continued.
Yes.
And by the end of October, sums in excess of the 134,000 had been paid out by you.
Lordship, was right. Yes, that's right. Yes. So that if those are, if you reverse those disbursements into the sitting balance, it's exhausted.
So if you had taken a snapshot on the 1st of November, when I dare say you still owed money, that money would not have related to any rents received before the 1st of October, because the payments made in October would have wiped out that liability. It would be a new liability.
Well, Lordship, there would be. I'm not sure that it would have wiped out that liability because there were new rents coming in, and of course the timing of those may have been between the 1st of October and the making of the and the disbursements. So in fact, the credit side is going up at the same time.
I follow that, but
So,
on a running account basis, applying Clayton's case, you apply the payments made in October to the earliest liabilities. Therefore, they will have wiped out, for the purposes of the 1st of November, any liability in respect of rents received before the 1st of October.
yes, I think that's right. Yes, they come off. They would come off the top line.
Yeah.
Yes.
So the starting point for the taking of the account ordered by Mr Justice Moylan would be a sitting balance of nil, would it?
Your Lordship, that's right. Yes.
Well, only if
Because
you
of the
started
way-
at the 1st of November, not if you started at the 1st
But
of
not if you start at the 1st of October. That's right. If you start at the 1st of October, the sitting balance is 134,000, whatever it is. And I say, well, there's a waiver in relation to that sitting balance. So Lord Nugee observes that it should, and it puts it very simply, that's a zero sitting balance at that point. You then have to carry out the account, and it's not strictly an account because that's not the Moylan order. The appellants were allowed to bring claims, and then there is a remedial in respect of the rents. that
So
were received
you
after
say,
that.
in effect, that the Moylan order wipes the slate clean as at the 1st of
Yes.
October 2014.
Yes, and then you look at the income after that date, and you take from that whatever deductions arise in the relevant period, and that's exactly what the judge did, and that's why there's no double counting.
But it is recharacterising the effect of the three first disbursements, because as you've just accepted an answer to my Lord Justice Newey, at the time, October, November 2014, when you paid 30-odd thousand to the revenue for VAT, and when you paid 80,000 and 50,000 to Docklock,
Yes.
those payments would, by virtue of the rule in Clayton's case, have been appropriated to the 134,000 as at 1st of October. You say the effect, if I've understood it correctly, the effect of the Moylan order is you draw a line over everything before the 1st of October, and you start again with a new account, what's come in since the 1st of October, what's been paid out, and the fact that those three payments were paid out in October and at the time would have been regarded as discharging the pre-October balance
Yes.
gets recharacterised because the pre-October balance is
Has gone.
effectively reduced to zero, so they're then available to be set off against the income that comes in after 1st of October.
Exactly so. Yes.
Well, that is-
necessarily recharacterised because
Yes,
there's no sitting balance anymore. So
because
you
it's been waived. And I
necessarily reverse what the appropriation in the underlying account, and you
so
started
so
a new account.
Mr. Lightman is right that your argument depends upon the Moylan order in the MWIA retrospectively recharacterising the appropriation that would have taken place at the time.
within the wider intent to waive claims before and
Yes.
to waive claims after the relevant period. So that's the effect of the waiver.
Yeah.
And the parties intended to waive that. Now, and one can take that from, in fact, the Deputy Master's judgment. They said we were not allowed to claim management charges that accrued before the relevant period, nor after it, but only within it.
Yeah. All right. Well, was that a convenient moment, Mr. Letman?
Your worship, yes.
2 o'clock.